Mr. Chairman, thank you for having us here today. I'm Gene Veno on behalf of the American Association of Public Insurance Adjusters. I also want to thank Minority Chairman Anthony DeLuca for last year's assistance in stewarding this bill. As we know, Representative Dom Costa, prime sponsor. But before I begin my 4 minutes and 30 seconds remaining, I go back to 1991 when I came to this committee. At that time, our good colleague, Representative Nick Calafala. And he said to me, Gene, what's a public adjuster? And I had the opportunity at that time of explaining to him what they did, the value they brought to the consumer, the homeowner, the business owner. And we became involved in the legislative process back then, educating the legislators on what the value that public adjuster did bring. And I want to thank Nick for that, because at that time there were certain issues that were being raised back and forth, and we had good relationships with the Department of Insurance, and that was my education on public adjusting. And over the 20 years that I've been before this committee on behalf of public adjusting, we always looked at the value that it brings to the consumer, but also not just from the standpoint of what does it do for the public adjuster or the insurance industry, but what does the license stand for? Now, let me be clear about this bill here today. American Association of Public Insurance Adjusters, we unequivocally support 561 if it eventually becomes 424. As you sat here last year in the March meeting when Representative Gaccio brought 1736, which was the fraud bill, we supported it. We were the first organization of anyone at this table to support that fraud piece bill. And we worked with Art McNulty, at that time Executive Director, to craft an amendment that would see that bill pass. As you know, both of these bills last year, 1736, the fraud piece, and House Bill 2370, made its way 199-0, unheard of in the years that I've been over here, and it's 30 years. And I have to congratulate the committees, both committees that worked tirelessly on that. And as Mr. Yanofsky said, there were many issues that we had to concur with. It wasn't a 10-day business rescission, it was 15 days. It wasn't other issues in that bill that we're really supportive of, we had to be opposed of. And we looked at it from the time frame that this bill, if it was worked with all the various groups at the meeting, the stakeholder groups, we could come to a bill that was reasonable and favorable. And it ended up passing 199-0. And I want to commend, at that time, Art McNulty and Kathy McCormick for bringing the stakeholders together, because they worked very hard. Let me wrap up on a few points here. Our testimony is now on the record. I have with me our attorney, Attorney Holly Soffer, who can speak on an issue which we brought up on misleading, which I think we have clarification, and also Mr. Bill Undercoffer, a public adjuster for many years that could answer questions later on during the course of the hearing. Would you like to speak on the misleading, if you will, please?
Yes, thank you. Good morning, everyone, and thank you again for allowing us to speak about the public adjuster profession and the value that a public adjuster brings to the process, as well as our support of House Bill 561. The only concern that we have is in Section 7 of the bill and how it relates to another earlier section, Section 682. And I apologize in advance because my testimony will be a little technical. So Section 7 is the same as House Bill 424, in which certain limited violations of the Act are now a third-degree felony. And at the time House Bill 424 was drafted, those sections were very carefully scrutinized, since conviction of a third-degree felony could impose jail time. House Bill 561 later added a few words to one of those sections. It was Section 6A2, a violation of which is now considered a felony. Previously, 6A2 said that engaging in a fraudulent transaction was a violation of the Act. Then the words "or misleading conduct" were added to that sentence, so that engaging in misleading conduct is now not only a violation of the Act, but also a third-degree felony. Engaging in misleading conduct isn't defined anywhere in the Act and is difficult to interpret, but will now be considered a felony. So what we propose is to add a sentence that clarifies that engaging in misleading conduct, while still a violation of the Act, will not be considered a felony unless such conduct rises to the level of fraud. And this is a point that we've discussed with the proponents of the bill, including the Department of Insurance, the Insurance Federation, who have all agreed to this minor clarification in the bill. And with that clarification, we support the rest of 561, as Gene has stated, for the reasons he stated as being favorable to the consumers as well as the profession.
And I'd like to wrap up by saying, Mr. Chairman, that it was Mark Twain that wrote, when you find yourself agreeing with the opposition, take pause and reflect. And I believe we did that, all of us, the last 12 months to look at this bill. And we believe the bill is in its best form and it should be passed without amendments. Thank you.